Hi, my name is Joe Bartolomeo. I'm a Social Security disability lawyer based in Oregon. I have an office in Astoria, Oregon, and I have an office in Hillsboro, Oregon. I represent claimants before the Social Security Administration seeking disability benefits. And in today's video, I'm going to talk about one of the witnesses that we will not often see, but occasionally see at a hearing, and that is the medical expert. The medical expert is somebody who is retained by an administrative law judge to review your medical records and provide an opinion about a couple of different issues in determining whether you meet the definition of a disability. So what I'll do is I'll talk about the different first, let me do this. Let me talk about who these people are, where they come from. Then we're going to talk about the two major issues that they're going to testify to, maybe even three major issues that they address at a Social Security disability hearing. So who are these medical experts and where do they come from? Medical experts, let me go back and kind of tell some war stories maybe. When I first started doing Social Security disability hearings in the Portland, Oregon office, we would all show up at the office and everybody would be there in the room. And there were, the judges were a lot more willing, a lot more able, I don't know, maybe both. They were calling medical experts in as expert witnesses a lot more frequently. It was more often than not that there would be a medical expert at a Social Security disability hearing. And then what I've noticed in the last maybe 5 years or so is that you see that less and less. And I believe there may have been some policy changes, and it may be that the judges have to make more of a showing to whoever the powers that be are to justify having a medical expert on the case, because they do charge for their time. These people are psychologists in mental health disability claims, in other physical health disability claims. They will be internists, medical doctors, they may be internists, they may be neurologists or neurosurgeons or orthopedists. It depends a lot on what kind of disability that you're claiming. So the medical experts come from all over the country. I've had psychologists that testify from North Carolina, from Dallas, from and Oregon, where we do our hearings, but they can come from anywhere in the United States. And I've had one this week, I had one from Utah. These people, these physicians are oftentimes, not always, but they're oftentimes retired, and they do this consulting work or expert testimony work kind of as a side gig. They may work for a company that is kind of like a booking agent that provides these expert resources to the Social Security Administration. Some of them are more liberal in the way that they interpret the disability rules and listings. Some of them are more conservative, and you get the whole gamut. I've had medical experts come in a case that looked pretty hopeless and make the day for my client. I've had medical experts come into hearing with a very strong case and kind of shoot my client's case down. And so, you really don't know what you're going to get with a medical expert unless they are a frequent flyer. What happens more recently is it's rare, not rare, it's not very often that you see a medical expert coming into a Social Security disability hearing, but they do testify, and almost never are they in person. In fact, I can't even remember the last time a Social Security hearing included a live medical witness. So that's who they are. They don't examine you. They look at your records. Sometimes they may look at other parts of your file. And what we'll talk about next is what they're testifying about. So the testimony of the medical expert, I'll break it down into three categories or three topics that they hit on. The first thing that a medical expert will testify to is whether you have a medically determinable impairment. And I have another video that talks about all of the different things that you have to prove with a disability claim, and one of them is that you have a medically determinable impairment or a severe medical problem. And basically what that means is there is objective medical evidence. That could be an x-ray, it could be an MRI, it could be a blood test, it could be a physical exam result, but there's some objective evidence, something that a doctor can see without talking with you, that verifies your diagnosis. And then there has to be some evidence that it limits your ability to do any kind of work activity. And that is not a very high hurdle to jump over because it doesn't have to be a disabling impairment. It just has to impair your ability to do work in some way. So that's the first thing that a medical expert will do. Now, usually that's not an issue. But in a hearing this week, I had a psychologist testify as a medical expert. I didn't have her testify, the judge did. And we had a client with several different mental health conditions, long-standing and pretty serious. And I was, nothing really surprises me anymore, but I was kind of surprised that this psychologist did not identify a certain diagnosis, because to me it seemed pretty obvious, but who am I to know, right? But she was just not convinced. And you'll see that especially with psychologists and mental health experts, is that they may be a bit more finicky about identifying a diagnosis because they rely upon this document or this book called the DSM-5, and I'm not even going to get into what that is. But that's the first thing that they identify, is the medically determinable impairment. Now, after that, they go into whether you meet an impairment listing, which begs the question, well, what is an impairment listing? An impairment listing is it's like a checklist. And when a judge is evaluating whether you're disabled or not, if they figure out that you haven't worked and you have a serious medical problem, the next thing that they're going to do is figure out whether you meet an impairment listing. The impairment listings are an appendix to the rules. They used to be called the Blue Book. And there are 12 chapters, and each one has a group of medical conditions. So for example, for an orthopedic disability, chapter 1 applies. And within that chapter, there are several different conditions. So if you have a disc herniation or degenerative disc disease in your lower back, then we're going to look at listing 1.04. And in that listing, there are certain criteria like positive neurological findings, MRI findings, radicular symptoms. That means if you have a bad disc problem in your neck, you're going to have numbness going down into your arms. Does it fit the right anatomical pattern? In other words, if you have a disc pinching on a nerve between the 4th and 5th neck bone, does the numbness in your hands and your fingers correlate? Is that the right nerve? Does it all fit? That's one of the criteria. And then there are several others. And if the medical expert testifies that you meet an impairment listing, you won the case. If the judge accepts that testimony, then you're good to go. But most of the hearings that we go to, the reason we're there is you didn't meet a listing, but your condition may have deteriorated, unfortunately, for you, and you may meet a listing by the time you get into the hearing. So that's the second thing that the expert will testify to. Now, if the expert doesn't feel like you meet a listing, then the third issue they're going to address is what your residual functional capacity is. Residual functional capacity means what can you still do in a work setting? How long can you stand? How long can you sit? How far can you walk? How much can you lift? Those kind of things. And so what the medical expert is doing is they're looking at your medical records and they're forming an opinion about what they think you can do in a work setting. And that opinion, it may be a giant leap. And sometimes, in my opinion, it is. But they will come up with what they feel your physical abilities are in the workplace. In a recent hearing, I had a medical expert say, my client didn't meet an impairment listing, but the expert still testified that my client would not be able to work full time because of her medical conditions. So the residual functional capacity opinion obviously is important. Usually the judge is going to accept the medical expert opinion at the hearing, but not always. I have seen, it doesn't happen very much, but I have seen situations where an administrative law judge will not accept that opinion. So, and then I've seen where judges accept the opinion, but you can tell it's a bitter pill for them to swallow. So that is what the medical expert testifies to at your hearing. Now, you may have other opinions in your exhibit file. For example, you may have an opinion from a treating doctor or a treating psychologist or some other healthcare provider that is different than the medical expert opinion that from the doctor or psychologist that testifies at the hearing. So it's not the end of the world if the medical expert at the hearing doesn't support your claim. So that's the medical expert at the Social Security disability hearing. I hope this is helpful for you. If you have questions, contact us. I'll leave a link below with the YouTube version of this video. I'll also leave my website address, and you can always call us. That still works as well. Check out our free guide I talked about. It's the Social Security Disability Guide. It's an ebook. It addresses all of the issues that I can think of on the Social Security disability claim. So I hope this video was helpful. Thank you so much for watching. Take care.